plaintiffs. Order to show cause.
Thank you, Your Honor, and Happy New Year.
Happy New Year.
So, as an update, an introduction to today's proceedings, it's apparent that the torch has been passed to the court and to the judiciary to make the determinations on compensation. The supposed committee report that was to become law on January 1st, according to reports, has taken effect in some manner, so that new paychecks went out yesterday at new rates, and everyone is proceeding apace with the results of that report. One would not know it to look at the legislative law as it stands today. Sections 5 and 5A remain unchanged according to the state of New York. The law remains that annual salaries for legislators is $79.5, et cetera, et cetera. That would be also consistent with what has happened in the judiciary law that was supposedly changed 2.5 years ago. It still records the wrong salary amounts for all the judges in the system, which points to the problem with this whole process. I don't think the state can point to whether or not this committee's report is a law or a regulation or what it might be. They've responded to the motion since we were last here, and nothing has changed in the state's favor or the defendant's favor, but has actually weighed in the balance of granting a preliminary injunction. Mr. Hasty, in his individual capacity and as Speaker of the Assembly, has also filed an order to show cause to file an amicus brief in here that also supports the plaintiff's position more than it does anything the defendants may be saying. Why do I say this? Well, let's work backwards on the criteria for a preliminary injunction as a starting point. The preliminary injunction is supposed to just keep the status quo, keep the balance of equities where they belong, the balance of hardships where they belong. Let's talk about what was the bargain that was made by the elected officials when they ran, statewide elected officials when they ran in November, the legislators when they ran in November, and the state officials under Executive Law 169 when they were appointed their positions. They all committed, when they did that, to the compensation levels that were in place in 2018. All the plaintiffs are asking for in this case is for the status quo to be maintained. On the other side of that, the parties who are affected by this compensation determinations, are getting the benefits of their bargain. Unless the state or others know of other promises that were made to each of these legislators, state officials, statewide elected officials, or other state officials that haven't come up in the papers, they're getting what they expected when they started. That's point one. Next, let's go to irreparable harm. The state filed its response, and I was curious about this, if you recall, when we were having the temporary restraining order proceedings, because the state seemed to maintain that it could just deduct amounts. If these compensation levels were deemed unconstitutional, that they could just go back to subsequent paychecks and deduct the amounts that were overpaid. The reality is, however, that each of those persons that is receiving this higher level of compensation is currently not a party to this action. This is declaratory judgment action seeking to have the report of the committee and the law and the results of it declared unconstitutional.
Counselor, how does your argument reconcile with the third department case that was entered on December 27, 2018? The Center for Judicial Accountability and Elena Sapauer versus Cuomo.
With regard to irreparable harm?
Yes.
Not well. That case only goes to the probability of success on the merits.
Right. So let's turn to that. So tell me how your position. How does that decision affect your argument?
Sure, it's different. Each of the parts of the compensation that's under question in this lawsuit has a constitutional provision saying that the legislature must fix those amounts by law. Okay? The judicial article, however, says it must be established by law. In our papers, we set out the fact there's a difference between the word established and fixed. And we set out several instances where established and fixed are used in the same phrasing, but they mean different things. Established is something to set up, to create. Fixed means fixed. We're going to establish rent for this premises. We're going to fix rent for this premises. They mean different things. In addition, and so there's a distinction, and it has to be given meaning. You have to, under the rules of statutory interpretation, these differing terms within the Constitution have to be given their different meanings. Otherwise, the purpose of the framers is lost and missed. On top of that, that was an extraordinary circumstance where there was a Court of Appeals decision that basically set out the legislative intention for the committee that was then put in place. There was a long history from 2006 through 2009 to 10 timeframe where the judicial compensation was being used as a political football tied to legislative pay and all kinds of political machinations. And the Court of Appeals came down and said that it was violating the separation of powers to be tying judicial compensation up in these knots like that, and that it was threatening the independence of the judiciary. And we're going to the Marone v. Silver case, that it was stated that everyone agreed that judicial pay needed to be increased. On that, there was a committee then formed that came up with its recommendations for increases of judicial pay. And the Center for Judicial Accountability case that came down from the Third Department goes straight from the discussion of the ability to delegate authority straight to the Marone v. Silver and the Larrabee cases to basically provide, as them providing the legislative intent for that committee. So two things. There's a difference in between what's supposed to be fixed by law and what can be established by law. And the second is there was actually de facto legislative intent behind the Judicial Pay Commission in 2015 based on the court's directive to get judicial pay fixed and that it needed to be increased and that everyone agreed that it needed to be increased. So in terms of this committee and how it applies to this committee is acting on areas of the Constitution where the legislature is directed to fix by law. For 70 years, that has meant in the legislative law, section 5, that they state, legislators shall be paid a salary of X amount, all right? Because it needs to be fixed by law. It's not go establish a committee to go do this, go do something else, put something in place to get this done. That's the first part. And the reality is the legislature has done that on multiple occasions since 1947. They've gone and amended the legislative law. The second part then is the legislative intent. And that's if one were to assume that this committee was properly delegated the authority to go and do what it did with its report that has now become something that apparently has the force of law, that it was given the proper legislative intent, the policy determination, and the guidelines that go with it. And that was the case law from the Court of Appeals saying, and everybody agreeing, that judicial salaries must be increased, and the legislature then setting up a committee and saying, go look at all these factors and go do them. Now, where the plaintiffs do concede on this is that if this committee could properly be delegated the job of setting the salaries of statewide elected officials, there were sufficient guideposts in Part Triple H that was enacting that for them to establish the salaries of the Attorney General and the State Comptroller. It might have been the case for the state officials under Executive Law Section 169 that there were proper guideposts. The problem is that they went and rewrote 169 to put 4 different tiers of officials together, and then out of 2 of those four tiers, they gave the governor discretion to set salaries within those amounts, and they completely took over the legislature's responsibility to fix by law state official salaries. And in fact, they took over the legislature's ability, even if it had it, to delegate that authority. It went a bridge too far, 2 steps beyond where it could have ever possibly have been under the case law that supposedly supports all of this delegation. So that's the explanation for the December 27th decision from the third
Right,
party.
thank you.
So moving on, or now going backwards, I guess, we'll go back to the irreparable harm, and I'll finish that. The state offers nothing to indicate that it actually has the legal authority to take back the funds from the people that are receiving it today. There's the Court of Appeals decision in Nyberg v. Steingut is very clear that those people receiving that compensation may have a good faith defense. On top of that, they did say they had been receiving legislative allowances for a long time, and that was another mitigating factor. But those are 2 factors. There was a length of time and a good faith that were there. Or maybe the length of time modifies the good faith would be a better way of putting it. Sitting here today, none of us has any idea what defense any of the people receiving this increased compensation might assert. That renders any claim against them for that money back contingent. And it's fundamental debtor-creditor law that you cannot set off on contingent claims. And the case that the defendants cite actually says that, but in a different way, because they say the state ultimately could deduct the funds, or the set-off could take place because it became a set amount, a fixed amount, which is a good word for us to be using today, a fixed amount. And so there was no longer any contingency, and the defenses were academic. So, I mean, and that's just the way debtor-creditor law works. And the state actually cites the state finance law, was it 103, that has a good faith defense put out for employees when they're overpaid in good faith. So they acknowledge that good faith can be a defense from the comptroller making any correction. Where's the irreparable harm? The irreparable harm is that there's no guarantee, the state isn't stipulating that it's actually going to go collect that money from everyone. It was careful in its papers, it was careful in its affidavit to say it has the ability, not that it's making any representation that it's going to go get that money back. And the bottom line is, each of those persons has a statutory right. I know, the state's not fussy on its statutes very often, but here, their pay is divided up in 26 equal payments. So even if this report and the outcome of this report was deemed unconstitutional, each of them would still, each legislature, for example, would have a right to 1/26 of their 79.5 for the remainder of the year. So you just couldn't deduct it without some sort of order, a court order, some authority for taking that money back. And those people, let's talk about their rights. They get to assert their defenses to claims against them. They get an opportunity. So that makes this all contingent and not as easy as the state would have had the court believe back on December 21st and even in its papers before today. We've talked a little bit about the merits, but if I can go back to it, to stress again that in Article 3, Section 1, the legislator's power to legislate is made clear. The Assembly and Senate together make the laws in the state. Just 5 sections later, when it comes to setting salaries, the Constitution provides that the legislator must fix by law. It's simple. It's a number. They can figure it out and put it on paper and put it in. The defendants cite cases relating to the Department of Health and licensing of hospitals and that sort of thing, licensing of cable franchises, and PSC, the Public Service Commission's work on mandating that people put wires underground. All those things relate to complicated regulatory environments. And there's a good reason that there are laws, for instance, dictating how the power line should be organized in this in this state. There's good reasons. I was just in court a few weeks ago where I learned all of the rules about the top line must be the power line, the bottom line must be the telephone line, and there's rules about the inches in between. What I don't remember is the inches in between, and neither should the legislature. So for a good reason, they do general laws about important things like how the power line should be organized around the state and hand it off to the Public Service Commission, where that fills in the interstices, the gaps, the crevices, the areas that the law can't address.
But going back to your argument that the committee didn't have the authority to make this determination, if you look at the case that was handed down back on December 27th, in that decision, it states clearly, while the legislature cannot delegate its lawmaking functions to other bodies, there is no constitutional prohibition against the delegation of power to an agency or commission to administer the laws promulgated by the legislator, provided that power is circumscribed by reasonable safeguards and standards. Isn't that what happened here?
No.
And why?
Because there was no determination made. There was no determination made there was no policy determination made. The committee made a policy determination on its own. It determined that it was going to restructure the legislative compensation system in such a way so that everyone would be paid like full-time employees that the committee believes that they are. All right? That was not a policy determination made by the legislature. And that's fundamental, because when you do the math, when you do the math now, they're some of the highest paid legislatures in the country on a monthly basis for the 5 months they work. Everybody for eternity has believed the law is that the legislators are part-time. It happened in 1946 when there was a legislative committee talking about all this. They said, well, they're full-time, but the law and the Constitution is that they're part-time. Because their only job description in the Constitution, mind you, is to pass laws. It's not anything else, it's to pass laws. The legislature, according to the committee, is only in session for 5 months of the year. So that's a part-time job. Now, they might do things that may make them think it's full-time, but there's nothing new under the sun with this. This was debated in 1946, it was debated in a report in 1972, it was debated in 2015, and it was debated again here in 2018. What has happened is, all along, at every juncture, everybody says, yeah, well, we think it's really like a full-time job, but the reality is, the Constitution says it's a part-time job. In 2015, that committee's members said, well, we think there might even be a constitutional convention voted on to come up in a few years where there'll be a constitutional amendment changing the role of the legislature. So that's been it. It's been 70 years of everybody saying, we're constrained by the fact that it's a part-time position and we'd like to pay them full-time. This committee just blew right by that and made the policy decision itself that the legislature did not make. It's up for debate whether or not the legislature even has the ability to make that policy decision, to pass a law saying, yes, we're full-time, it's a full-time job doing this, we should be paid like that. But they did not do that. That is absent from anywhere in the enabling law legislation, Part H. It just says, go look to see if salaries warrant an increase. And as far as the committee knows, the Constitution provides it's a part-time job, all of the history provides that it's a part-time job, everything provides it's a part-time job. They get paid $79.5 for 5 months of work a year, which goes out to a pretty substantial sum when you annualize that. What is it? $190,000. That's a $190,000 a year job.
All right, so you've argued this likelihood of success in the merits and irreparable harm. Do you want to speak to the equities?
I started with the balance of equities, Your Honor. It's this. It's that every single person who's getting paid under this compensation scheme, I might be overstating that, every legislator, every statewide official, and probably most of the state officials under 169, if we went back to the 28 compensation and put the preliminary injunction in place, would be getting what they bargained for, would be getting the exact amount of pay that they were expecting to get when they ran for office or when they were appointed their position. This committee did not meet until after the election. So for anybody who was a legislator, any statewide official, they're getting the benefit of the bargain. Anybody that was appointed under 169, unless they were hired after January 1st, is getting the benefit of their bargain. So the balance of the equities favors maintaining the status quo. This is not some turning everything upside down. Maintain the status quo and let it happen that way. What you're getting from the state and from Mr. Hasty is this plea to sever, divide everything up, let the salary stay in place at these high levels, and they're probably thinking that they'll let the chips fall where they may on the other things later on. But this was a package deal, and they have to, the legislature at least, has to live with the consequences of its package.
Thank you. Is there anything for him?
Not at the moment.
All right. Ms. Lynch.
Thank you, Your Honor. With the court's permission, I'll start with irreparable harm. So on December 21st, when the parties appeared on plaintiff's application for a TRO, the defendants stated the general matter that disbursements of money are not irreparable harm. Full stop. And then we followed that with an explanation, a general explanation of how the controller's office could simply reconcile any overpayments that would be declared to be overpayments.
How do you respond to Mr. McDonald's argument that the legislatures are not parties, so they would have the ability to file an action against any reduction in their salary in the future?
Right, the only authority that plaintiffs rely on for that is State Finance Law 200 B 3 sub B, and that we address in our papers that is completely distinguishable. If there's an administrative error by the controller's office as to a salary, then only under certain circumstances can that overpayment be recouped. That's completely inapplicable here. To the extent that the salary increases are declared unconstitutional, then that is not an administrative error. So 200 State Finance Law 200 simply doesn't apply. And then the other authority that the plaintiffs rely on is the Nyberg case. That case is distinguishable because the court made a decision not to order restitution retrospectively, because for years the legislature had been doing yearly allowances, and so there was reliance on that long-standing practice, and so that was the reason. That is completely inapplicable here. If the statute is declared unconstitutional, and which we think it will not, and I will get to that, but if that happens, it's a simple reconciliation process. And it's pure speculation and an attempt to graft on law that is completely inapplicable to try to counter that. And we put in the evidence in our papers from the controller's office, and plaintiffs have not put in any evidence to counter that, aside from the speculation and inapplicable law. So, and just briefly on the equities, as we stated on the 21st and put in our papers, if the pay increases are already in effect, so if the if the pay raises are struck down, the reconciliation process will apply. If we flip that around and the preliminary injunction is put in place, that whole process that's already in place will have to be reversed. And then once the decision on the merits is issued, if the statute is upheld, they'll have to reverse again. So we'll have 3 reversals, and it's just very disruptive, and it actually kind of is a good segue into the likelihood of success on the merits, because the equities really should be considered in light of the fact that the merits lean towards upholding the pay raises. So there's a vast body of case law that says that the legislature cannot delegate policymaking functions, but if there's a policy set forth, the legislature can delegate administration of that policy, and as long as there are standards and safeguards. And that body of case law, it kind of culminated with this decision on the 27th in the Center for Judicial Accountability case that is exactly applicable here and completely dispositive. Now, plaintiffs attempt to extract compensation issues from that vast body of case law. It doesn't work. It clearly doesn't work in light of Center for Judicial Accountability, but this idea that for some reason the judicial pay raises are different because the Constitution says that judicial salaries are established by law is somehow different from the legislative salaries which are set by law, that's a reason to extract legislative salaries out of this vast body of case law. It just doesn't work.
Is there in your position a difference between the word established and fixed?
Well, I don't know, I don't have a dictionary in front of me, but I mean, I don't disagree that those two words could have different connotations. You know, established could be an initial establishment, whereas fixed could mean to keep something in place that has already been established. I don't disagree, but the difference between whether compensation needs to be established by the legislature and whether compensation needs to be fixed by the legislature is a completely different question from whether those two function, whether administration of those two, of policies related to those two functions is permissible. And in both cases, it is. There's absolutely no analytical difference between delegating administration of a policy as to legislative salaries and executive salaries, and there's no difference between that and delegating administration of a policy as to judicial salaries. So there's no analytical distinction. The legislature clearly in Part HHH, the policy is adequate compensation. It's as clear as day. That's the policy. And then the standards are all of the factors that the committee is instructed to take into account. And those are almost identical to the previous commission in the Center for Judicial Accountability case. It's almost identical. In fact, the committee had an additional factor to consider. So the policy is set, adequate compensation, the standards are set, all of the factors, and then the safeguard is set. The committee's recommendations don't automatically become law. The committee's recommendations only become law if the legislature allows them to, in which case it did. So the legislature is still setting the compensation, and they're delegating the administration of that task. And honestly, Your Honor, I believe that the Center for Judicial Accountability case is absolutely determinative here, and I'll leave it at that.
Okay, thank you. Mr. McDonald, do you wish to respond?
Yeah, let's start at the end. So maybe somebody can figure it out for us. If whatever the committee's report was that came out on December 10th wasn't a law until the legislature didn't do something, then what was it? I mean, it's just this massive mess. It's either, whatever the committee's report did is either a law or it's a regulation.
Was the committee's recommendation, did that become a law as of January 1? What's your interpretation?
Yes, because it can only be, because it goes into force on July. Yes, it goes into force on January 1st, I believe, either unless modified or abrogated by the legislature.
And it was not modified or abrogated?
Yeah, and let's talk about what that means. That means that the legislature had to pass a bill. The only way you modify or abrogate a statute is by passing another statute. There's no other way to do it.
So you agree that it became a law on January 1st?
No, I don't know what it became. I don't know. That's what they're saying. It's their law, it's their mess. I'm just saying what the practical effect is. When they say it has the force of law as of January 1st, 2019, unless modified or abrogated by the legislature. The only way the legislature can do anything about that is by passing a bill. That's the way legislative process works, is set out in the legislative
And they
article.
did not pass a bill after that.
No, they left it for you to decide. It's the judiciary's job now. And what I didn't hear either is, so the policy set, adequate compensation. Nobody knows what that means. You could pull everybody in this room and nobody would know what that means in the terms of the legislature. It may be the case that one knows what adequate compensation is for the Attorney General because you can look at the job, you can look at comparative things, you can do the things that are supposedly these guideposts in the law. That's fine. With state officials, probably the same. There's probably enough there that you can determine what's adequate compensation for the other state officials under 169. For the legislators, no, because nobody determined what their job is. The committee went out and said, well, unless we're accepting what the job description was before the committee started for each of them. So the AG's job is described, the comptroller's job is known, each state official's job is known. Everybody's got job descriptions. Your Honor has a job description. The judiciary article goes on for 37 sections on your job descriptions. So everybody knew what judges should get paid based on what you all do. So, but when it comes to the legislators, everybody knows there was the policy before was that they were part-time, and this committee then said adequate doesn't mean what, doesn't have anything to do with this. We're deciding they're full-time, we're paying them like they're full-time, and now this is adequate. That's a policy decision that the legislature never made. And there is a distinction between established and fixed. There is an analytical decision, and it also plays, it's convenient that it relates to the judiciary article and the judiciary law, because there is a separation of powers. And what happened in the Marone v. Silver case was illustrative of the fact that perhaps the framers knew what they were saying when they said established by law versus fixed by law. Fixed by law means go pass another statute. What happened in the aughts, we'll call it, was that the legislative pay, the state official, executive pay, and everything got caught up in the judicial pay, and probably wrongly, because there always wasn't out. Established by law meant maybe they could set up another commission, an independent group, to maintain the independence of the judiciary and keep it out of the legislative forum. That makes sense. Established by law means then go find a way to make sure judicial compensation is set, and history played out that way. The facts played out that way. Here, however, it's clear when the Constitution was amended to allow legislators to fix by law their salaries, it was contemplated that that would be a statute subject to the governor's veto and subject to public opinion. That means the legislators pass a law that they're accountable to the taxpayers and subject to the governor's veto power. And so that's basically where it boils down on the merits of this. There is a distinction between fixed by law and established by law, and it fits, given the roles of the various branches of the government in all of this. Finally, just back to the irreparable harm. The state finance law case on the good faith defense is not our case. It came from their papers. I'm pointing out that even the comptrollers of the state finance law recognizes where there's overpayment, people might have a good faith defense. The case, Nyberg v. Steingut, it's not about the allowances or whatever. The actual statement from the court is that in denying restitution, we accept the rationale expressed by the appellate division that restitution of monies received under a statute subsequently declared to be unconstitutional is not always required. That's the point. It makes everything contingent. I don't know what the circumstances are that the legislators or the state officials or the AG might argue in court if called on to repay these funds, but it does make it, this case from the Court of Appeals says it may not always have to be paid, and it may be because it was a long-standing practice, and they may have some sort of good faith defense, simply because it was constitutional at the time as far as they knew. And then finally, with the, even with the balance of harms on all this and the hardship that the state supposedly had, when we were here on the 21st, the state had the option of saying, okay, fine, yeah, this is going to be a lot of work, this goes back and forth. But they said to the court, this is easy. We can get this done. If something happens down the road, we can reverse it and change everything and change the deductions and take it from everything. It's the state who's changing their position here. All of a sudden it's this massive hardship that they have to rejigger their payroll system when just a few weeks ago they said, no, we can clean that up later. It's completely disingenuous. And so the balance of the hardships weigh in favor of the plaintiffs. The irreparable harm does, because you're putting it on the plaintiffs to go out and chase down all this money from all these folks, which means actually that almost 300 of them would probably need to be named in this action for restitution under the state finance law. And the merits weigh in favor. It's straightforward. The legislature should go back, pass a statute if this report is correct. They've got a good working document to start from. Go pass a statute and let it take effect in a couple of years. But don't be passing along and breaking 70 years of understanding and knowledge about how it's supposed to work, making legislative salary changes.
Your Honor, may I be heard?
We're going to turn to your order to show cause once we
Yeah, if I could be heard, I'd like to talk about the plaintiff's order to show cause.
Well, you're not a party yet to the proceedings, so I'll let you speak maybe to your order to show cause. Ms. Lynch, is there anything further?
Very briefly, Your Honor, I'd just like to say with respect to the equities, all the state is saying, all the defendants are saying is that reversing course once is a lot easier than reversing course 3 times, and we're not contradicting ourselves. And I just would like to say that the Marin case dealing with judicial salaries, the separation of powers issue in that case had absolutely nothing to do with the question of whether judicial salaries are established or fixed. Nothing to do. So the legislature is absolutely permitted to set a policy as to legislative salaries and delegate the administrative tasks. Thank you very much.
You're welcome. All right, now we are going to turn to the order to show cause filed by Mr. Silverman in support of the motion for leave of Speaker Carl E. Eastie to appear as amicus curiae, both individually and in his official capacity as a Speaker of the Assembly. Mr. Silverman.
Thank you, Your Honor. I would like to start, if I could, by talking a little bit about the motion that the plaintiffs have filed, because I think it goes to whether or not the Speaker has a separate voice, a unique opinion in this case that I think that will be helpful to the court, and I'll do it as quickly as I can.
I'd like to have you speak to your order to show cause that was filed and that's returnable today. So why don't you tell the court why you're seeking to, what your position is on behalf of Mr.
Sure, Your Honor. I think it would be demonstrated by the arguments on the plaintiff's motion, but let me just go to it directly. The Speaker has a unique view in this case that's not represented by either side. The Speaker is the head of the Assembly, one of the 2 bicameral houses of the legislature. This case involves both legislative pay and also what are the constitutional constraints and authorities of the legislature to delegate its authorities, particularly with regard to salary increases. There are 5 factors laid out in the Kruger case in assessing whether or not amicus should be granted. The first is whether or not the motion was submitted via an order to show cause. It was here. The second is whether or not the affidavit indicates that the amicus brief, the second is whether the brief was attached to the affirmation. It was. The third was whether the affidavit indicates that the amicus brief would invite the court's attention to issues not discussed by the parties or be a special assistance to the court. I think it clearly would be in this case, Your Honor. There are unique positions that the Speaker has that are different from the positions that the plaintiffs has proposed. They're different than the positions that the Attorney General has proposed. And just to give a flavor of what that is, one of the hardships that has not been discussed yet today is the hardship to the legislators if the preliminary injunction as proposed is enacted. The plaintiffs mentioned several times that the purpose of a preliminary injunction is to maintain the status quo, but that is not what their injunction proposes to do. They ask to freeze salaries as they were on December 31st, 2018. They do not ask, however, for the decrease in stipends to be for the stipend levels to be maintained as they were on December 31st, 2018. And so while the plaintiffs talk about expectations that the legislatures may have had of what their salary is, if the preliminary injunction was to be granted, the legislatures would return to $79,500 without stipends, except for 15 stipends that would remain. And so, to the extent that we're talking about the expectations of the legislators and what the preliminary injunction would do to them, I think the Speaker has a really important role to play in those conversations, and a role that, at least thus far in the proceedings today, has not been addressed. Relatedly, there has been no discussion today about the importance of the salary increase for the legislators in particular. The Speaker spoke to the committee in open session, testified before the committee, and explained how the salaries still remaining at 1998 levels had caused a hardship to the legislators, that while the cost of living has skyrocketed in the state, particularly with regard to transportation, childcare, healthcare costs, salaries have remained the same, that the purchasing power that was $122,000 in 1998 has actually fallen to just $50,000, while at the same time the annual revenue, the household revenues in the state have increased by 2/3, while the legislature salaries have stayed the same. I think that's an important component both of what the committee did and in considering the equities and even in looking at irreparable harm, and yet it's something that hasn't been discussed at all today. And so I think that the Speaker, again, adds some really valuable and important information in that regard. The fourth Kruger factor is whether the amici would substantially or improperly prejudice the party, specifically with regard to delay. That's not the case here. We filed the order to show cause and our proposed amicus brief on the day that the state's opposition brief was due, so there's been no delay in the proceedings. In addition, there's been no improper prejudice. I understand that the plaintiffs don't love the arguments that the Speaker has made because they, at this particular point in the case, tend to favor the state and propose that the preliminary injunction should be denied. But there's nothing improper. There's no improper prejudice there about any of the arguments that the Speaker has made. The Speaker has intended, and I think has added value to the proceedings, both today and in our papers. Finally, does the case involve an issue of important public concern? That's the final Kruger factor, and it obviously does. The plaintiffs have spoken to that and spoken to that quite eloquently. So let me talk just finally about a couple of things that I think that the Speaker has added to these proceedings that is of value and a reason why the Speaker should be allowed to participate as amicus. I've mentioned his valuable experience and information to contribute as the leader of the Assembly and both his knowledge about delegation of authority, delegation of legislative authority, as well as sort of the facts on the ground with regard to legislator compensation. I think the Speaker has also presented issues that have been unaddressed by the parties. I talked about the balance of the hardships, but the Speaker also talked about severability in his brief, to the extent that the court thinks that there may be some provisions, some recommendations that the committee proposed that may be unlawful. The Speaker's position is that those can be severed, particularly from the legislative salary increases. We heard the plaintiff say, and let me get close to the exact language. The plaintiff said in their opening presentation, the plaintiffs concede if the legislative authority can be delegated to the committee with regard to legislative and statewide executive officials, that the committee acted within the scope of its delegation, within the scope of its statutory delegation, which leaves the only question for this court to decide on the merits, whether or not this case is somehow distinguishable from the CJA case. And it clearly isn't. The parties, the plaintiffs have focused on the words fixed by law and established by law. They focus on fixed and established, but I think they're missing what is the key in both of those terms, which is the word law. It's not about fixed by law or established by law. The provisions require salaries to be set in the law, either fixed by law or established by law. With regard to the judiciary, it's established by law. With regard to the legislatures, it's fixed by law. But fixed and established are not the key words. The key words the key word in each of those provisions is law. The recommendations of the Committee for Legislative and Executive Compensation pursuant to Section 4.2 of Part Triple H says that each recommendation shall have the force of law and shall supersede, where appropriate, inconsistent provisions of Section 169 of the Executive Law and Section 5 and 5A of the Legislative Law unless modified or abrogated by the statute.
How would the court determine what the intent of the committee was if it's not taken all together? So how would the court determine that the salary increase is okay but not any restrictions?
Sure, Your Honor. So two things on that point. One is I believe that the appropriate thing to look at is the intent of the legislature, and the legislature, when it delegated its authority, clearly focused on salary increases. Straight from Section 1, the provision of Part Triple H talks about recommendations, review, and analysis of the adequacy of, among other things, salary, the salary of the legislatures. It says something very similar in Section 1. In Sections 2.1, and in 2.2 it talks about whether or not the salaries warrant an increase. So I think it's clear from the legislative language. I think it's also clear from the committee's report that salary increases, that salary really was the focus of what the committee was looking at. The legislature had said to the committee in the very legislation that established it, your job, the lodestar of what you are supposed to be doing, is to look to make sure that salaries and compensation are adequate. We do not believe that they're adequate now. Here are 8 factors that we want you to look at. There's all sorts of constraints that we're going to put on the recommendations that you can make in terms of phasing it in. It has to be only 3 years. Any phase-in requires consideration of the legislature's performance, but all sorts of guideposts in terms of adequacy and the factors, and all sorts of guide rails in terms of the limits on what the committee could do. And I think that makes very clear that the focus of both the legislature and the committee was on salary increases. The second thing that I would say on this point is I think that if you look at the recommendations themselves, it's clear that some of them are obviously severable. The pay increases are set to take effect as of January 1, 2019, whereas the limitations on outside income don't take effect until January 1 of 2020. So those are clearly severable. They're not connected. They're not so intertwined, to use the language that the courts have used. They're completely separate in the recommendation. And I think the same can be said of the stipends. The reason for getting rid of the stipends, the committee explains, is because the stipends put New York out of step with how other states do stipends. The committee was concerned about ethics, was concerned about fairness. You can look at all of those concerns with regard to the stipends and say the stipends should be reduced or not, totally separate from what happens with regard to the salary increase.
Anything further, Mr. Silver?
Just one second. Oh, one final point, Your Honor. The plaintiffs in their rebuttal asked the rhetorical question, what does adequate mean? And I think that is a very good indication of this is a proper delegation of legislative authority. The legislature says, here's what we want you to do. We want you to determine adequate compensation. But it is not for the legislature. The legislature could say precisely what that means, but it could also say, here is the term. This is what we want you to do. Here are the factors to go about doing that. And I would just point the court to the Sleepy Hollow case out of the 3rd Department and Levine, which I think is out of the New York Court of Appeals. And in those cases, the terms that the commissions or agencies were supposed to promulgate rules to satisfy were public interest, promotion of the health. And I think that adequate levels of compensation and salary fits right into that bucket. Thank you.
Mr. McDonald, would you like to put your position with regard to the order to show clause?
Yeah, I'll start with saying that was a really nice presentation about what Mr. Hasty intends to add that he didn't bother to add in his proposed brief when it comes to legislative stipends and pay and the importance to the legislators regarding their purchasing power and so on. It was a full-throated opposition to the motion for a preliminary injunction that didn't offer any of that extra information for the court. And that's the point here. The point here is that here is this individual coming in who is not a party to the proceeding, who is simply trying to defend his pay raise. And he goes on then to just argue in opposition to the preliminary injunction motion, and does not offer the specialized, unique perspective that is being represented here today. So, for instance,
he is bringing a perspective of a severability argument.
Yeah, well, yeah, which is interesting because that's really subject to this litigation. That was page 1 of the memorandum in support of the preliminary injunction, that this whole compensation scheme is premised around it being making legislators full-time, eliminating stipends, and capping and prohibiting and capping outside income. Now, and let's clarify here. All the preliminary injunction is intended to do, and it's clear from the order to show cause, is stop the disbursements pursuant to the committee's report under Triple H. It had nothing to do, and set the status quo. There's nothing about the motion for a preliminary injunction that is saying keep the committee's reporting placed in any way. It's saying go back to the old as far as what are dispersed. So the number 160 on the list can get their $9,000 under the stipends, under the proposed order. It's to go back to the way things were, and that's all that's been asked of. So let's highlight then what this severability thing means. Okay, it says, I guess, adequate as to what? Is it adequate as to a full-time job? Adequate as to a part-time job? If it's a part-time job, according to the committee's own documents that are on its website, it took the top 10 legislative pays, plus it added New York City and it added the United States Congress. And New York City's a 12-month, sits for 12 months, the Congress sits for 12 months, and it did everybody's base salaries. We had a bunch of controllers in the room who couldn't do a spreadsheet and add a further column as to what that meant by month, but I did it. Excel works pretty well. And I took a monthly base, and by 2021, under this recommendation, the monthly pay for the 5 months of session duration that the committee says New York has is $26,000. That annualizes out to a $312,000 salary. Now, if they meant for that to be, it seems to me that a $130,000 salary that annualizes out to $312 is pretty outrageous, which means they meant for this to be $130 to be a full-time compensation. And part of it.
McDonald, do you oppose the amicus curiae? Are you opposing the order to show cause? You do not want Mr. Hasty to have his argument filed with?
We can talk about it being a motion to intervene. If he wants to be a defendant, we can talk about that. But he's acting like a party, not as a friend of the court. There's nothing about what he's offering that's serving the court and helping the court. In fact, he's doing the opposite. I mean, they go through a 5-page analysis of the Boreali v. Axelrod case, and there's just information, just kind of statements that are just, frankly, kind of outrageous. They said this committee has special expertise with rates of inflation and comparing legislative salaries around the board. I mean, Mr. Hasty himself testified about how inflation has affected salaries. We just heard it today about how inflation, if we've got an assembly or a legislature that can't figure out how inflation works, there's big problems for this state.
All right, so you oppose the amicus?
I did.
All right, thank you. Ms. Lynch.
I would just like to add that the defendants do not believe that the severability issue is directly relevant to the PI motion, because we do not believe that the court needs to rule on outside income or the Executive Law 169 issues to rule on the PI motion. That's all.
All right, thank you. And Mr. Silverman, would you like to respond to anything?
I would just say, Your Honor, the first thing that plaintiff's counsel said was that none of the things that I said were, today were in our brief, and I think the brief demonstrates otherwise. And I'll just leave it at that.
Right, thank you. The court will be reserving its decision on both of the requests this morning. Is there anything else the parties would like to put on the record?
Nothing from defense, Your Honor.
No, Your Honor.
No, Your Honor.
I want to thank everyone for coming this morning. Have a great day. Court's adjourned.